Well, welcome everyone, or as we say in New Zealand, kia ora koutou katoa. Nice to see everyone. We've got a great turnout tonight, and lots of people have registered. So, as I was saying to the others, they're going to go away and watch it later, so not to be missed. So we've got a really interesting subject tonight, and I'm really pleased that Jackie's leading us in on one of our favourite topics, and that is, of course, vexatious litigants. How do we control them? So, talking about putting an end to parenting litigation, vexatious litigants, and harmful proceedings, or what sometimes might be known as barring orders. So, those of you who know me, I think everyone knows me, Inga Blackford. I'm the president elect of the Asia Pacific chapter. I am stepping in tonight for John Spender, our president, who can't make it. But on that basis, I'm going to hand over to Jackie as your moderator for this morning, this afternoon, this evening session. Jackie, it's all yours.
Uh, Thanks, Inga. So today or tonight, wherever you are, we're going to hear from Alex Verdon KC, who's recently become in-house counsel at Stewart. So we've had a bit of a run of Stewart speakers. That wasn't intentional; it's just accidental. But he was when I was making inquiries about speakers for this topic, he was recommended to me because he's got such considerable experience in high conflict parenting disputes. And we've also got William Sloan, who you all know, an accredited family law specialist and current Vice President of the Asia Pacific chapter of the International Academy of Family Lawyers. I could spend more time reading out their extensive CVs, but I won't because that will take too long. But I'm just going to share my screen. Of course, it worked before and it probably won't now. But share. Great. So I'm not going to have a PowerPoint for very long, but I thought because we're actually dealing with a bit of legislation here, it might be a good idea to put it up on the screen, talk you through it briefly, and then we'll move on to the more interesting stuff, which is the cases, which have some interesting factual scenarios. When I was planning this session, I did it on the basis that, well, what started it is that in Australia, we've traditionally had vexatious proceedings orders, which are quite hard to get. So if you've got a litigant who's over litigating and not giving up, it's quite a high bar to meet. And a few years, or in 2024, Australia introduced what's called harmful proceedings orders. And they were a recommendation of the Australian Law Reform Commission because the Australian Law Reform Commission thought, well, the vexatious litigant stuff is really high bar. We need to have another approach which looks more at the impact on the victim. So the ALRC looked towards England, which has what I thought were called barring orders, but Alex assures me are called Section 9114 orders, which isn't quite as catchy a title. I know they have something similar in Texas and I think Florida, but because I found out that Australia and England were actually dealing with these a bit differently, it seemed like enough to cover in one session without going to the other jurisdictions, or they recognise there is something similar happening in the US. Then I've got to try and move my screen on, and of course it won't move. Next. So, yeah, I've just said what I'm going to talk about. Just quickly looking at vexatious proceedings orders, this is the Australian legislation, which will not be the same as every other jurisdiction or every other area of law in Australia, but it's pretty similar. So it's looking at frequent institution of proceedings in Australian courts or tribunals and doing it. And the court then can make an order staying or dismissing part of proceedings, prohibiting the person from instituting proceedings, and any other similar order. And if that vexatious proceedings order is made, then the party who wants to institute proceedings would have to seek the leave of the court before they're able to institute the proceedings. So as I said, the Australian harmful proceedings orders were based on the English position, and I'm going to hand over to Alex to take us through that legislation.
Jackie, thank you very much. I'm not sure if I'll be able to coordinate with your PowerPoint in the sense that I've already got 4 or 5 screens open and coping with another one operated by you is going to be impossible, but I'll do my best and I'm sure you will be able to coordinate with what I'm speaking about. Yes, I definitely specialize in high conflict cases. I would say that 98% of my cases are high conflict cases. But what is interesting, and when I started exploring this topic and discussing it with Jackie and William, what is interesting is that Section 9114 orders are, in fact, quite rarely used. And so I began to kind of look more as to why that is and whether there is going to be a change. It's worth bearing in mind that our original statute, the 1989 statute, included 9114 orders there. So the statutory provision is in fact very old. It's a quarter of a century old, 1989. The amendment, section 91A, came in 2022. And that simply says the circumstances in which the court may make a 9114 order include, amongst other things, where the court is satisfied that the making of such an order would put the child or the other person, normally the parent, at risk of harm. So that is more analogous, I suppose, to the harmful order, the harmful order that you're talking about, Jackie, and that you have. But obviously, it only specifies one set of the circumstances. The court can make the order in a whole range of circumstances. But I need to say right at the outset, Jackie, it's still quite rare, despite a case we'll be coming to later, where the Court of Appeals say, really, the court should be using these orders more frequently, given the completely different social climate we are now in. We tried to find MOJ, Ministry of Justice, statistics on how many such orders have been made since 1989, and surprise, surprise, we haven't been able to find them. So forgive me if what I say to you is based on anecdote, experience, and speaking to lots of colleagues. And I would say generally that Section 9114 orders always have been underused in England, which perhaps reflects a concern that really, it's a very draconian intervention to stop people applying for orders. That said, I think there is a change coming, and we'll come to a case called Re-A in a moment. Jackie, I know you've got the slides there, which everyone can look at later. Do you want me to go through a little bit more detail as to the statutory circumstances which apply and how the courts traditionally have looked at Section 9114?
Well, I think just talk about, I mean, I don't know if you can see the slide, subsections 3 and 4, just what the test is.
Yeah, so firstly, there are two tests. When the court makes a Section 9114 order, the court has to look at all the circumstances, and it has to be, it's an unusual order to make. And it was traditionally thought to be an exceptional order where there was harm caused to the child or one of the parties, or there was a history of excessive applications made. That was the original thought. As I've already said, 9114 specified the words "a risk of harm to those people," but that was a statutory amendment. Previously, the court was obviously allowed to take into account the risk of harm. And then if an application is made where a Section 9114 order has been made, then the court, pursuant to subsection 4, has to look at whether or not there's been a material change of circumstances. And I'm sure that makes sense to everyone listening. If you apply very quickly after that order's been made and there hasn't been a material change of circumstances, then the court obviously won't lift the 9114 order. And Jackie, you're right, it's not a very catchy title. It's the one we all use. We don't use the word barring order, but effectively a 9114 order is a filter. It doesn't stop you ever applying. It simply means that someone who has a right to apply, namely and normally a parent or someone who has parental responsibility and is looking after the child, then would have to apply to the court for permission to apply. So it's a hurdle that is put up for those people who have a right to apply. And then the court has to look at material change of circumstance. And the other thing I, of course, want to bring to everyone's attention is that in our system, these orders, generally speaking, are time limited. Although that's not a statutory provision, that is something which has developed as a result of case law looking at the various situations. Generally time limited, but not always time limited. And that's because, of course, the court wants to balance the interference as against the protection, looking, of course, at the welfare of the child, but also the reality that this is stopping someone who normally would be allowed to apply as of right from applying. So
thanks, Alan. So I thought we better move on and get William to talk to us about the harmful proceedings orders, and then we'll go back and look at how the case law is, how the legislation is applied to the cases. William,
sure.
Can you give us a bit of an overview of the legislation here?
Sure, thanks, Jackie. Maybe just to start where Alex finished and the idea of time limitations, because that's something when we were preparing for today that I noticed was different. There is no express reference in the Australian legislation to time limits being imposed. The language of the section itself just suggests open-ended orders that last essentially forevermore. We also had a look at some of the reported decisions in Australia where these orders have been made, and none of them refer to time limits being imposed, at least in those reported cases so far. It doesn't mean that maybe an adventurous judicial officer might not consider a submission about a time limitation, but certainly there's no express reference to it in our legislation. Going back, I suppose, to the top and the requirements to get one of these harmful orders in Australia, it's very similar to, as Jackie mentioned, the legislation in the UK. It expressly references harm to the other party to the proceedings, but it's also wider than that, and it can be anchored on harm to a relevant child. So it's either harm to the other party or harm to a child, which is similar to the position in the UK. It is a discretionary remedy in Australia. It's necessary but not sufficient that you demonstrate the harm. If you get past that first hurdle of demonstrating harm, the judge then retains a discretion as to whether or not they're going to make one of these orders. So, and there have been some decisions where the judges have been sort of at pains to emphasise it's not enough alone that you get to the point of having demonstrated harm, that now I, as the judicial officer, am bound to give you one. I still retain a discretion, and I might or might not, in the exercise of my discretion, give you one. The concept of what constitutes harm, the legislation gives some guidance about what can be taken into account, and it's an inclusive rather than exclusive definition. Types of harm that are given as examples which are within the scope include psychological harm, mental distress, impact on the capacity to care for a child, and also financial harm. So you can see immediately it's a broadly cast concept of harm. And I think Alex mentioned there being a more modern view in the UK of what these provisions are meant to be achieving. And I think certainly you would say that the Australian legislation, by the time we got it, picked up a more modern view of what constitutes harm because of how widely they've cast it. The Australian legislation also gives some guidance as to considerations that the court can take into account. And again, these are not exclusive, they're just suggestions, and there might be other factors that get considered. But the considerations include the history of the proceedings, and you'd expect their reference to repeated applications and other similar things. The extent to which proceedings have been instituted frequently. It's important to note there, and I think one of the cases we'll come to later in the session, you don't have to have multiple applications having been made. It might well be that this is the first time an application's been made, and even then you might be able to get a harmful proceedings order. So frequency of prior applications is a consideration, but it's not a mandatory one. And the legislation also references as another consideration the cumulative effect of proceedings to date. So those are considerations that are required to be taken into account. Another aspect of understanding the requirements in Australia is the level of proof. There's one of the decisions that's been delivered in Australia has sort of been clear on this point of where that bar is set. And it's been said in that decision that proof that harm would be suffered is not required. It's a lower bar. It's sufficient if there are reasonable grounds to believe that harm would be suffered. And it seems like a fairly fine distinction, but there is a distinction there. And the requirement for proof will be met if there are facts sufficient to induce the belief in the mind of a reasonable person. So that's where the bar is in terms of the evidentiary or proof level that's required to get one of these orders in Australia. Jackie, I'm not sure whether you want to do it now or later. The question of what are the consequences once one is in place.
You're on mute, Jackie.
Sorry about that. Thank you, Alex. I thought we would talk about the cases and get away from the sort of the legislation up on the slide, because I think the facts are pretty interesting,
Okay.
and you talk a bit further about those. So what we're going to do next is Alex is going to talk about quite a good case example from England, how the law has been applied there, and then William's going to comment on it as to what he thinks might happen in Australia or what things it brings up there. And then we're going to do the same with a Western Australian case, because William wants to talk about a Western Australian case, rather than one of my Fed FCOA cases. But then we'll talk about some other cases from both jurisdictions, and just comparing and contrasting what would have happened in the other cases. And then we'll finish up with a bit of time for questions. So we'll probably have to, the cases are pretty interesting. We'll probably have to cut off and not get a chance to talk about them all. But I'll put the list of cases in the ASPAC Ed when it goes out. So if you want to do some further reading, you can. First of all, Alex, do you want to talk about REA, a 2021 case from England, which you mentioned before?
Yeah, definitely. And it's the case that William was talking about, a more modern approach. But just before I do, sorry, what I forgot to mention earlier is, of course, the court can make such an order of its own motion. You don't have to have someone applying for it. And moreover, because of our practice direction we've got called Practice Direction 12J, paragraph 37A.1 of that practice direction says the courts are required to consider a barring order, a 9114 order, in every case where there is a finding or an admission of domestic abuse. So that kind of links to the harm point that we were discussing earlier. I made the point that anecdotally, we all think that these orders are not being used enough and are pretty ineffective, and that is surprising. The bar is high. Case law has said they are should be exceptionally used. So I thought it would be really useful to talk about a case called REA. It's a Court of Appeal decision. The leading judgment is from Lady Justice King, and it really does put 9114 into a modern context. And I'll tell you a little bit about the facts quickly. A 7-year-old child living with the father, mother only having supervised contact, so unusual in that sense. A 9114 order was made for 2 years, again, time limited, which is interesting. The mother appealed against various things, including the 9114 order. And interestingly, she said a supervised contact order for a mother to a 7-year-old for 2 years is a very unusual order and stops the development of a more natural relationship. And so she appealed the supervised contact point and the 9114 point. It's clear from the Court of Appeal judgment that the litigation had involved countless applications historically, and a deluge of emails from the mother to the father, who although the mother, ended up as represented by lawyers, had gone through a long period of time as a litigant in person. The mother, when she was a litigant in person, had complained about nearly all the professionals in the case, and the judge had sent the father hundreds of emails. Her behavior, thankfully, had improved a little bit when she was legally represented, but not that much. And there were 6 lever arch files of documentation when the case was really about supervised contact and how contact could be developed. So that gives everyone a sense of how extreme it was. The mother's conduct was described as a campaign, and Lady Justice King in the Court of Appeal approved of course, the 9114 principles as had been applied by Re-P, which was the original guidance case. But she said, interestingly, that in the 25 years that had passed, the forensic landscape, the evidential landscape, has changed completely for all of us. And what she meant by that was smartphones, social media, emails, the high rise of litigants in person, the bombardment of messages, and the oppressive behavior of people in a way which didn't exist 25 years ago, and the deep distress that causes to the other party, let alone the child. And she said in that case there was a much greater scope for a greater use of 9114, particularly when judges form the view that behavior by one parent amounts to, and her word was, lawfare, which is a word we're now using all the time when a case appears like this. Now, since that Court of Appeal decision, I'm not sure really if 9114s are being applied as much as Lady Justice King thought they would be. I still don't think they are, because again, without making this all about my anecdotes, my cases are nearly all, regrettably, lawfare, because that's the sort of cases I do. And I would say that 9114s are a small minority of cases, maybe less than 20%, maybe less than 10%, which gives you an idea that even now they're not being used that often. And when they are being used, they are really time limited. Remember, this one was only 2 years, which in the scheme of things is not that long.
William, would you like to comment on that case and Re-A and what you think the differences might be to Australia, and then move on to talk to us about Babic and Ticini?
Sure. Well, the obvious difference is the one that Alex mentioned, is around that idea of time limitation. And I mentioned it as well in my comments earlier, that expressly the Australian legislation doesn't contemplate time limits. It doesn't mean that maybe a judicial officer might not think to make an order that includes one, but there's certainly been, in the cases I've looked at so far, none of the cases have even countenanced time limits. They're just open-ended orders that are there forevermore, essentially. So I suppose there's one point of divergence at the moment in the approach UK side by side with Australia. Alex, in his sort of commentary on that case, mentioned all of those things that resulted in distress for the party, and certainly our legislation, when it got to drafting, has picked up that concept of distress, and it now expressly mentions it as one of the types of harm that is recognised and is to be recognised. So, I mean, I think you would expect that an Australian judge would take a fairly similar approach in being willing to hear the evidence about the lawfare as all driving the arrival at that conclusion that there is distress being caused. And if there is distress at that level, then you've got harm as it's sort of constituted in the legislation, and you get your order as a result. One thing I noticed is there's now a whole body of cases in Australia where not only is the harmful proceedings order made at first instance, but it then goes on to be appealed. And our legislation has been interpreted to apply so that the leave is also required if you want to. So if you have one of these harmful orders imposed on you and you want to appeal the imposition of that on you, you are the bringing of the appeal itself is subject to the harmful order, and as a consequence, what might have been an appeal that you could have brought as of right is now an appeal that you can only bring if you can obtain leave. And the Australian judges seem to be quite enthusiastically, at least so far, knocking the appeals out without actually getting to the substance of the appeal, but just on that front end question of whether there should be leave and saying, I'm not even going to give you leave to appeal. Because I mentioned that appeal point just because I'm conscious, I think Alex mentioned the REA decision that he was speaking about actually went on appeal. So potentially that's maybe somewhere where it might have been different in Australia, that if that had been run as an appeal in Australia, it might have just been knocked out in a fairly cursory way, but the refusal to grant the leave, because it sounds like in Alex's summary of the case, they went further and actually got into the substance of the appeal itself. So there's maybe a couple of sort of observations on Australia versus the UK. And then going to the Australian case, there's no particular magic. And as Jackie has mentioned, we are going to circulate a much longer list of Australian cases that we are aware of that have been delivered so far. And we could have frankly picked any one of them. It just happens that I was familiar with this one. So there's an element of laziness on my part to share with you a case that I have some familiarity with rather than having to go and read another case. So the one I'm going to mention to you is called, what's reported as Babic, and the full citation for that will be in the papers that we're going to distribute to you. One thing that comes out of Babic to me is just how quickly these orders seem to be available to get in Australia. And people who are familiar with family law litigation in Australia will understand that because of lack of resources and too many cases in the system and the usual raft of factors, it is not uncommon for Australian cases left to their own devices to run for literally years, 2-3 years even, is not unheard of, to get from an opening application through to a final decision after a contested trial. In Babic, there was one of these applications or an order made, and that happened, I think, in a space of about 3 months. I think the person who the order was being sought against tried to re-enter the system in June, and by September of the same year had one of these orders imposed on her. So I suppose that's something that emerges from Babic, is how relatively quickly these orders can be sought and then obtained. The background to Babic is that the parties had been in the system for many years. The mother attempted effectively to re-enter the system by bringing a new application just 6 months after there had been a full contested trial, and final parenting orders had been made following the delivery of a reserved decision. So there's obviously a preliminary issue there about had there been a sufficient change of circumstances, and that's a whole other topic that we could have a seminar about whether there is or isn't sufficient change of circumstances to warrant a variation of a final parenting order. But for our purposes, we can take it that the judge in this case was more than adequately satisfied that there had not been a sufficient change of circumstance to warrant this family re-entering the system. And so the judge's attention swiftly shifted to not only kicking this present case back out, but also making sure that there weren't further attempts to re-enter the system. And that took the judge to these new provisions about harmful proceedings orders. The decision contains, as I've mentioned, some of that commentary about where the proof level sits. And I won't repeat what I've said earlier there. The judge was also at pains to say, and which is kind of apparent when you look at the legislation, the types of harm, whether it's psychological or distress or financial or other, that are mentioned in the legislation are essentially examples, but there might be other types, and you don't need to take too narrow a view. Other facts specific to this case, which the judge thought important in arriving at the decision to grant one of these orders. The parties had been involved in litigation in family courts of some shape or variety for what was approaching 10 years at the point where this case was before this present judge. So you can get a flavour there immediately about wanting to have these or give these people some resolution rather than continuing to hold them in the system past their 10th anniversary. There was also evidence from experts which had been given during the course of the contested trial just months earlier. And those experts included people who had interviewed the children, and the experts who had interviewed the children all confirmed that there was, or that the children were being subjected to significant psychological pressure, as it was being described in the reports and the evidence from the experts. The experts went on to describe the children as being, and this is their language, fatigued and exhausted, which in the context of 10 years of litigation, probably hardly surprising. And also that the children were at risk of developing permanent or ongoing conditions, including chronic anxiety and other mental health conditions. So again, there's a fairly easy pathway for the judge to get to a finding of harm or prospect of harm. And other facts in this case, which were seen as appropriate to ground the granting of the order, included that when there had been supervised time, the children had been given a safety signal that they could use if they wanted the time to be brought to a conclusion. And there was evidence that that safety signal to conclude the time early had been used on a number of occasions. So all of that factual background got the judge to a point where he was satisfied that there were grounds to believe that the children would suffer harm. So this is one of the cases where the harm is being anchored on harm to the children as distinct from harm to the other party to the litigation. And the result was that the order was made. So that's an example, and there are obviously others, but there's an example.
Thanks, William. Alex, would you like to comment on that case? What you think, whether you think the English courts would have dealt with it the same way?
Yeah, I think the short answer, Jackie, is I think they would. I think those facts and circumstances are pretty extraordinary, given it was only 6 months after a contested hearing. It's interesting. I mean, in our statute, there's no time limit in the statute before you can apply again. But generally speaking, even our most difficult clients generally don't apply within months. If they seek advice, generally speaking, we say to them, you kind of need to wait a year unless there's an emergency. So I would have thought the English judge would make the same decision. I'm interested, though, if you don't mind, Jackie, me asking William, firstly, how was that decision made? Was it made on paper? And on new evidence? I think you're saying, yes, there was new evidence from the experts to say that such a new application would cause more harm. So was it made on new evidence? Was it made on paper? Was it made on oral evidence? And was it made on submissions? Because I'm impressed with how quickly your court was able to deal with that.
We are too, Alex.
Okay. It's down to William.
The answer is the judge was a different judge who was hearing the harmful application compared to the judge who had run the trial some months earlier. But although it was a different person, they have access to the same continuous file. So the judge who's dealing with the harmful order can read back into the file and can see. And some of those expert reports that I was mentioning were reports that were delivered for the purposes of the original trial.
Got it.
And the harmful judge was taken to and did have regard to that evidence that had been run for trial. I suppose particularly in the context of it still being only months old. I suspect, if you were attempting to get a judge to read back into the file and it was now some years later, they might be more resistant, and you get a question about weight of, how much regard should I have to that now relatively old evidence. But in this case, the judge was willing to look at that old evidence, but it was supplemented by new evidence from the father, and essentially confirming that she had continued to behave poorly even in the period post the making of what were meant to be final orders. So to answer your question, it's a combination of old evidence from the original trial supplemented by new evidence from the father.
Okay, that's really clear. But the decision was made on paper, on written evidence, rather than anyone giving oral evidence.
I'm not sure
Sorry
about
for
the
that
question.
curveball.
I'm not actually sure whether that did include examination of her, or whether, because we have our evidence in chief given on paper, and then you obviously can cross them if you want to. Okay. But whether she was crossed in this one, I'm not sure.
I don't think so. Just from my brief looking at the case, I don't think that. I think it was relying on the affidavits.
More happened on the papers, yeah.
But we'll move on to talk about another English case. Got a long name: Andrew James Griffiths and Kate Elizabeth Kniveton, a 2024 case. Alex, this is another time-limited English case. 3 years. It's a long time.
Yeah.
What happened in this case?
So the child was 5.5, lived with the mother. The father had video contact 30 minutes a week, and the father applied for supervised contact, leading to unsupervised. The proceedings had been going on for 4.5 years, and the judge made serious findings of domestic violence against the father and actually scaled down the contact from video contact, which is obviously pretty minimal, to letterbox contact only, because the judge found that, in fact, the video contact was not only harming the children, but more importantly, harming the other parent who had to sort of facilitate it. And the facilitation of the video contact was causing harm, distress, and upset to that other parent. And the court made a 91-14 in that case for 3 years. And the principal reason, interestingly, because it's a 2024 case and therefore post Re-A, the interesting point is that the main reason given was to give the mother a break from the strain, giving the primary carer a break, given that she had been involved for something like 4.5 years in pretty horrendous litigation. So that is a good example of a first instance judge putting into effect what Lady Justice King talked about, giving a party a break from it. And the facts of it are pretty extreme, because obviously letterbox contact for that period of time, 3 years, unless an application were to be made to lift the 91-14 bar, is quite a draconian intervention with family life.
Thanks, Alex. William, I'm going to jump a case, so I'm sorry about that. I just thought we could talk about Brown, but I think Garside's probably a better one, because we're going to run out of time, I think. And that's one of the cases where you mentioned before there doesn't have to be a history of litigation.
Yeah, there is. I think in the papers you're going to get 2 separate Garside decisions. One is effectively a first instance decision, and there's also one where it subsequently went on appeal. Not dissimilar to the case Alex was mentioning, the fact pattern in this one was that the father was agitating to see a resumption of a relationship with the children. It was in the context that he had actually not only been accused, but actually convicted of a serious crime of violence against one of the children. And so understandably, he was starting from a position of really not having any significant relationship with the children and was agitating to have some resumption of a relationship with the children. The result, unsurprisingly, was that he was that the harmful order was granted against him. And I'm just turning the page for my notes of the appeal. And so the appeal one is one in that category or basket that I mentioned earlier, that it was essentially knocked out at the leave question, because to run the appeal against the existence of the harmful order, you need leave. And so the judge who was dealing with the appeal refused to grant the leave. So that's sort of the factual summary in Garside in the two decisions that are mentioned in your papers.
Yeah. So, Alex, do you think an application for a Section 9114 order could be made in England on the basis of there being no history of litigation at all, but in circumstances like in Garside, where it was the father's first application, really?
I think that would be unusual, but there's no statutory reason why it's not possible. But that would be really unusual in my view.
Well, the factual matrix here is probably pretty unusual too, having a father who's been convicted of a crime against one of the children.
For sure.
Yeah, I think there's some care needed here, and that's why I emphasise the word convicted. And the more normal level that it's at by the time it's in the family court is that there's accusations of criminal behaviour which haven't yet been ventilated in the separate criminal proceedings. But so factually, I think this one maybe isn't kind of your normal fact pattern.
No.
So
and I think he'd actually been in prison for 4 years. So
yeah.
I think it's a fair back of time on anyone's scenario. So moving back to another case from England, and then I think we might have some time for questions or some discussion. I was going to talk about, sorry, I had a list.
Did you want P&D?
Yep, P&D would be good.
Yeah. I mean, P&D isn't a 9114 order, but I thought it would be interesting to throw into the mix because it's another way that the English court can actually stop another parent causing harm to the parent who's looking after the children and or the child itself. And I just wanted to bring to everyone's attention, I'm sure they're all aware of it in their own jurisdiction, as well as barring orders, of course, the English court can limit the exercise of parental responsibility in quite a wide range of different ways by using, and we call them prohibited steps orders, Section 8 orders, to stop a parent doing something. Now, the facts of P&D were pretty extreme. There was very bad, excessive, extreme violence, very serious violence perpetrated by the father to the mother. The mother and the 3 children had gone into hiding. They'd moved into a number of different secret locations to avoid being found by the father. The father wasn't having time with the children. The mother had sought injunctions against the father, limiting contact between the two to indirect, but she also applied to limit his exercise of parental responsibility. Because obviously, even if a parent is not seeing a child, if they can be involved in the usual way with decisions about school, health, where the children are living, whether they go abroad or not, then they can use that as a real way to harm the other parent and cause them real distress. So I thought P&D, which is a 2014 case, is an interesting one because in that case, the court made injunctions restricting how that father could exercise parental responsibility, and actually made orders saying that father couldn't take any steps in relation to parental responsibility at all, which is a different way of achieving the same thing and arguably is even more effective because he could not do anything. He couldn't be involved in any exercise of parental responsibility. And that order was made, I think, until the child reached the age of 18. And that's the ultimate protection, isn't it? because just going back to the earlier point we made, a 9114 order is only a filter. It doesn't stop an application being made. It just puts another hurdle up to make it a little bit more difficult. This is the ultimate protection, but this really is used in very rare cases. And the facts of that case are, as I said, pretty unusual.
William, do you want to comment on that?
Yeah, just maybe a question to clarify with Alex. When you're saying that the steps are prohibited in relation to the particular aspect of parental responsibility, does it extend to being able to essentially complain to the court about how the other parent has exercised the parental responsibility? Like, so he obviously no longer has a say when the particular decision is being made, but if he thinks in the exercise of that power that's now held solely by the other parent, a poor decision has been made, does he have some sort of a right of recourse or right of appeal to kind of have it second guessed back in court?
Yeah, I mean, good point. The short answer is that person could apply to court for a different type of order to allow him to be involved. But on the history of this case, and given the judgment in this case, well, he didn't appeal. And as far as I know, that order stayed in place so that the mother in that case could say to every agency, this is the court order, he's not involved at all, and therefore he doesn't know. And I suppose the practical effect of that, William, is after a short period of time, he wouldn't know where they're living, he wouldn't know which school they're at, he wouldn't know how to communicate with them, he couldn't communicate with them, and therefore, in reality, his options would be pretty limited. But theoretically, he could apply to court. But given that type of order prohibiting him from doing any of those things until the child was 18, he didn't appeal, and I don't think he would have any scope to appeal.
He took the hint.
Thanks, Alex. So just one more case before we move to questions. William, Carey and Prescott, another 2024 case. All our cases are very recent because the legislation is very recent and they're mostly successful, but this was another unusual factual case too.
Yes, I'm sorry, I'm just finding my notes about Carey and Prescott. So as Jackie mentioned, a 2024 decision, as most of them are, apart maybe from the appeal ones where they've gone on and had that squabble about the appeal and whether leave's required for the appeal. So in Carey and Prescott, there was a child who was aged 12 and so obviously was sufficiently mature a child for there to be some regard to their wishes and preferences as to what the arrangements were. And in this one, it was a unwavering, I don't want a relationship with my mother position on the part of the child. And there in fact had not been a relationship. There was evidence about what's described in the notes as the mother's antisocial and criminal behaviour towards the paternal family. Separate from that was her own state of mental health, and there was evidence about her having been admitted to psychiatric facilities. She had also committed offences against the father's family, which had resulted in her being imprisoned for those offences. So it gives you a sort of an example of the level of the relationship. The aspect, I suppose, that's somewhat unusual in the fact pattern there is that the father who the child had been living with passed away, and so it was the grandparents on the father's side, the paternal grandparents, who were seeking to step forward and to be recognised. So their application was to be recognised as being significant people in relation to the child, so the rest of the world would recognise them. The mother sort of effectively cross-applied and said, well, I'm the mother, I'll have the child, thank you. And so you've got the contest between the grandparents and the mother, and the result being that there was a harmful proceedings order made against that fact pattern, which when you look at the facts is probably really hardly surprising, even with the sort of overlay of that slightly unusual fact aspect of it being the grandparents, given the level at which her conduct was at, it's probably unsurprising that the harmful proceedings order was granted.
I mean, it is more of a contrast, I guess, to the vexatious proceedings orders where there would be no way that the grandparents would have got a vexatious proceedings order
Correct. Yeah.
against the mother because they didn't have the history of litigation. And what is it, I think interesting, we haven't really talked about in the Australian cases, is that mostly people are making the applications but both for vexatious proceedings orders and for harmful proceedings orders, and the judge is just taking the easy way and making the harmful proceedings order because the bar's so much lower, and they're not even considering the vexatious proceedings application. Is that your reading of the cases too? That's my reading of the cases.
Yeah, but why wouldn't, if you're going to run it, why wouldn't aim for as much as possible, make the target as large as possible, and if for some technical reason the judge wouldn't give you one, they've still got some remaining options that might be useful. But I agree. I think where they are run on the alternate, the lower bar gets crossed and the rest of it just falls away.
We've almost run out of time, but I wondered if there's anyone from a non-Australian or non-English jurisdiction who might have some comments about what's happening in their country. Anything similar?
I think Susan's got a question, Jackie.
All right. Sorry, I can't see. Thanks, Susan.
Can you hear me?
Yes.
In South Africa, we have what is called a decree of perpetual silence. And in 35 years of practice, I've never seen one. And it's time for us to update it because there really is some harmful stuff going on. I have a matter with a 2-year-old child where the father's been charged with sexual abuse twice, and she has to go through ARVs and internal examinations and that kind of thing. So it's really difficult.
Thank you. Anyone else? Maybe it is a pretty rare thing, these types of orders.
I had a question actually for Alex about the UK. The question, sorry, the case you mentioned, Alex, where they limited the parental responsibility for that father. Why was that instead of, for example, removing his parental responsibility? Do you have that as an option, or would it be considered too draconian?
Yeah.
I was just curious.
Yeah, we do have that as an option, but the test for that is even more difficult. And so in this particular case, the court decided to do a bespoke limitation. But the reality is, but when you knock out education, health, address, location, I mean, there's not much left really. Maybe change of surname, I don't know. But yes, we do have it, but it's very, very rare. Whereas bespoke limitation of parental responsibility, if you can, for example, show, one parent is being so unreasonable about school choice and it's just causing so much stress, then that's more common.
Could I make a comment very quickly from Japan?
Yes, Makiko.
Yes, we have, in a very rare case, we also have a kind of a system to terminate the parental rights. I mean, in a country too. So, but the requirements are quite high and it's quite rare. But it's a kind of similar type of actually method, I think.
Anyone else got a comment or question?
We have one in the chat box, Jackie, from David. Yes.
David Hodson, do you want to add something?
I think that's brilliant talk by Alex. Thank you very much indeed. In England, we have part-time judges. I've been a part-time judge, mainly finance, but I would agree with Alex. They are underused. My simple question to this group, to other groups, is it culture rather than law? Is there a culture in which the practitioners are reluctant to apply because despite other jurisdictions, in England, we have the green light to making these orders. And there are some appalling cases, as Alex has explained, where it goes on and on. Is there a culture issue? Is there a sensitivity to gender issue? Sorry, guys, to raise the issue, but I will. In that these are often made against dads, not exclusively, of course, but often made against dads. I throw that in. I also throw in the question, is it more likely to be made in a bigger city like London than in a small locality where tomorrow you're acting for the dad, and the next day you're acting for mum, and vice versa. I just throw into this mix amongst us all, are there other issues such as culture and practice, even when, as in England, as Alex has said, we've been given the green light, and these 9114 orders are crucially important to maintain peace and status quo. Certainly peace for the children. At the end of the day, is all about the children's best interests, and it's in the children's best interest there isn't the lawfare that Alex described.
Well, David, my theory is, for what it's worth, is that our amendments were brought in 2024 in the context of quite a big move to protect victims of family violence. So that's very different from the environment back in 1989 when yours came in. So it may be that it's just the right time for ours to have been brought in. Yep.
Yeah, totally understand that.
We've got to wrap up though. So could I just get a final word from Alex and then from William before we finish up?
I'd like to have an update in a year or two, and I'd like you to tell us whether you're using them more successfully than we have been able to.
I suspect we'll still continue to be using them successfully. They've gone off with a bang here.
Yeah, I agree. I think they've been enthusiastically embraced, and to pick up David's point, embraced by the lawyers seeking them, and embraced also by the judges being willing to grant them. So, because I agree with David, there's an element of the case doesn't even get to the judge if the lawyer's not going to advise the client to seek it. So there's that cultural aspect in the way the lawyers frame and run their cases and what they advise the client to seek and not to seek.
So David's right. It's a cultural thing, because there's still a big problem in England and Wales.
And even with the hint of that further round of amendment in your legislation, adding that A section beneath it to give you some clues of, hey, it's here, use it.
Well, thank you very much, William and Alex, for your presentation today, and I'm going to hand back to Inga.
Thanks, Jackie. Look, I know that there were a couple of other questions. I saw some hands go up. I'm sorry we couldn't get to you, but because we just simply run out of time, it was a really great session. Thanks, guys. Particularly interesting to hear about how it's going in Australia, because it might be something that particularly in New Zealand we might eventually do. We just at the moment don't have a government that's got any appetite whatsoever to bring about changes to do with family law. Their eyes are elsewhere, but it's something that I think practitioners in New Zealand are particularly watching. Those who had questions that couldn't get them dealt with this evening, feel free to email our speakers direct if you have a question about their jurisdiction or anything that was brought up this evening. I think, Alex, you're right, it's probably something we need to come back and talk about. It's really interesting. Just before we wrap up, I just want to let everyone know about next month's session. We've got a really special and different session next month. It's going to be on Wednesday, the 12th of November, and we're doing one of our cross-border or cross-organisation sessions. We're doing a collaboration with the Mumbai Bar, and we've got a session at 8:30 UTC on the 12th, which is going to be talking about marital assets, alimony and maintenance laws in India. And we're going to have judicial trends and comparisons. So we've got 2 judges from India. We have an English judge and a Hong Kong judge, and we're going to be talking about this, the developments in India in particular. So really encourage everyone to watch out. The information's about to go live on that. It'd be great to see lots of faces. I think we're going to get a fantastic turnout from India. It would be fabulous to see as many IAFL people there as possible. So thank you, Jackie, for moderating. Thank you, Alex and William, for speaking. And thank you, everyone, for being here this morning, this evening, tonight, whatever time it is, wherever you are. Evan, well done in particular, 5 a.m. your time. just in time to get ready and go to work, I'm sure. Okay, everyone. Thanks for that.
Thanks, everyone.
Bye.
Great session.
Bye.
Good night.
See ya.
Thank you.